Hey everybody, this is Do-It-Yourself Kangaroo Court number 11. Give them the liability. It's not a real court. Kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and which the result is a foregone conclusion because of the bias of the court or other tribunal. Again, it's not a court. And so this is going to be a short one. Anyways, copies of these documents can be found in my private group at Yahoo called Administering Your Public Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries and other books and forums, contact me privately at engineerwin@yahoo.com. You can also get it on the thumb drive. Donations to support this work are appreciated. I prefer gold or silver coin for all the Satanist order follower revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966. But as an extremely less desirable alternative, I can accept the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, and money orders. Send me an email for particulars. All of these judges are always dealing with statutes, and when acting to enforce a statute and its subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as a bought and paid for clerk. Okay, only in a ministerial and not in a discretionary capacity. Okay, they're a bought and paid for clerk. It's the accepted rule not only in state courts but of the federal courts as well that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes as a bought and paid for clerk. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as a bought and paid for clerk. So, all oaths must be lawful allowed by common law or some statute if they're administered by persons in a private capacity or not duly authorized. They're quorum non judice and void. And those administering them are guilty of high contempt. Now, this is a cite from Tomlin's Law Dictionary, 1835 edition, volume 2, but they're citing book 3 and 4 of Coke's Institutes on the Laws of England. And so that goes back to the 1500s. And so, this is as old as time itself. The point being is that they can operate in their official capacity or they can operate in their private capacity. All government officers, employees, judges, police officers, etc. can be in their private capacity or in their public capacity. You know, you go into like an Apple store and you see a cop in there in uniform. Well, do you think he's there in his official capacity or in his private capacity? I would suggest that he's probably there in his private capacity. He's just wearing that uniform to be threatening and intimidating to people. An officer who acts in violation of the Constitution ceases to represent the government. If they do anything that's illegal or unconstitutional, they cease to represent the government and immediately move from their public capacity to their private capacity. A clerk masquerading as a judge is not competent to do anything judicial like issue orders or warrants. A clerk masquerading as a judge is operating in his private capacity and has no immunity. And I've got court cases to support all this, but we're trying to keep this short, so it's in my other videos. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Brutum fulmen, an empty noise, an empty threat, a judgment void upon its face, which is in legal effect no judgment of all, and by which no rights are divested, and from which none could be obtained, and neither binds nor bars anyone. And that's Black's Law Dictionary, 4th edition. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on vid.me. Don't forget to follow me on Steemit. Don't forget to like this video, YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload on vid.me. Don't forget to upvote this video, and on Steemit, don't forget to vote and make your comments. There's the front page of my channel, and the arrow is pointing at the bell. And when you click on that bell, it'll have a little vibrating symbol there so to show that it's vibrating, which means that you'll be notified when there's new uploads. This is Steemit. The left arrow is where you upvote the article. The middle arrow is how many votes that it's got, and the right arrow is where you make comments. And this is also Steemit. The hand is touching the crypto wallet profile, and a little window comes down and where you can follow or unfollow somebody. Under international law of warfare, all parties to a cause must appear by nom de guerre because an alien enemy cannot maintain an action during the war in his own name. And so think about it. This is if they are talking to you, it's under a statute, then you're an alien enemy, and they're making war on you. A mixed war is one which is made by on one side by public authority and the other by mere private persons. So they're making war on you, and you're an alien enemy because you're a U.S. citizen, or they presumed you are, assaulted you with it, and the U.S. citizen is a citizen of the District of Columbia. And so you're foreign to Texas or Arizona or whatever state you happen to be in. And you're just rolling over and letting them do it to you. If they spell your name in all block capital letters, then they're operating in their private capacity. It's warfare, and it's in private capacity. And sometimes they even spell your name in upper and lower case. I've seen them start to do that in the federal courts. My procedure puts them into estoppel. In other words, you watch the video about the do-it-yourself estoppel certificates, and I send them out a registered letter, and I take away their presumptions and put them in the position that they have to honor their oath. Watch the do-it-yourself Kangaroo court videos, 1 through 10. Actually, now it's 11. But it puts them into estoppel. If they're attacking you with the statute, they're operating in their private capacity. See the do-it-yourself nil dicet judgment video. See the do-it-yourself self-inflicted problems video. When I serve them with a notice and demand, which is full of estoppel certificates, they put you on their round robin. Okay, in other words, a round robin is in sporting events where instead of one team just having an elimination contest, you go and you meet every opponent in the competition. That's called a round robin. The judge and the prosecutor disappear, and another one appears. Okay, and that happens every time. When I serve them with my notice and demand, every time a different judge will show up and a different prosecutor. Okay, they're putting you on the round robin. This shows that they intend to perjure their oath. They intend to go ahead and insult you with their commercial transaction. And so this video shows how to deal with that. And you give them the liability. See the martial laws coming from the United Nations video. See the international laws, a subset of canon law video. See the Roman cult slave scam video. See the slavery equals Roman cult video. See all warfare is commerce and all commerce is warfare video. Every taxpayer is assessed to K trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. That's a summary from this case in Bolins in 1912, and then a summary from the Congressional Record of June 13, 1967, from 5 pages of the Congressional Record. Is a citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive Sestake Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. The Roman cult is responsible for setting up for the Sestake Trust. For when they were driven out of all their former holds, they devised a new method of conveyance, by which the lands were granted not to themselves directly, but to nominal fees to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fee, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks, to be bound in conscience to account to a Sestake use for the rents and emoluments of the estate. That's taxes, folks. It is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's the cite from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And if the Sestake Trust is the foundation of modern conveyancing in 1835, it is certainly the foundation of modern conveyancing even today. Slater's protestations to the effect that he derives no benefit from the United States government have no bearing on his legal obligations to pay income tax. Unless the defendant can establish that he's not a citizen of the United States, the IRS possesses authority to attempt to determine his federal tax liability. So the court has given you the recipe right there. All you have to do is say, I'm not a U.S. citizen. An act to establish a code of law for the District of Columbia the legal estate to be the Sestake use, and that's located at 31 Stat 1432. And more DC code for the District of Columbia, which was approved on March 3rd, 1901 by the 56th Congress at 31 Stat 1189, and right up in the very front it says, and be it further enacted that an interpretation and construction of said code, the following rules shall be observed, namely, the word person shall held to apply to partnerships and corporations. And more DC code located at 31 Stat 1230, presumption of death. Okay, so they presume you're dead. They presume that it's the Sestake Trust they're dealing with. And this is codified at Title 15, United States Code, Section 44. In the definitions, it says a corporation shall be deemed to include any company, trust, so-called Massachusetts trust or association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest, and it goes through the same definition, except it does not have shares of capital or capital stock or certificates of interest. So this could easily include a Sestake Trust. Announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 because it avoids the advertising only. But if you like my work, it can be a donation. It's a modest donation, there's no doubt about it, but a whole bunch of people chipping in a little bit, it adds up pretty fast. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit. I cannot fight all the battles. That's the reason I'm doing it, is there's strength in numbers. Currently, I'm publishing one video a week. The link to my channel is at the bottom because I'm not can't have a customized URL until I have over, I think it's 1,000 subscribers, and I don't. Some of my exclusive content that I've uploaded to this channel is Arlington Private Information Share, Land Deed Training, Estoppel Certificates Training, Foreclosure Estoppel Certificates Training, Corporate Denial Training, Toll Roads Notice and Demand Training, Invoice Training, Notice of Void Judgment Training, Revocation of Signature Training, Third Party Witness Training. This is also, some of this has been uploaded already and some of it hasn't. There's federal habeas corpus training, revocation of voter registration training, criminal complaint training, lawsuit training, other training. Everything that is needed to free yourself is available for free on my free YouTube channel, Sovereign Living. This one is basically stuff that if you need to have a little bit of extra babysitting, it doesn't cost as much to because I require a donation if you want me to babysit you. But you can watch these videos and it's a lot less money than what would be required for a donation. All forms, files, and other instructions are available for free on my two private groups at Yahoo Groups and Google Groups. But this channel has exclusive content. There's the front page of the channel, and the top arrow is pointing at the URL so that you can find it. Some people had trouble finding it. The bottom arrow is pointing at the Start Free Trial button, and the reason that is somebody actually sent me a $1.99 donation, and I didn't know if it was a donation, if they wanted me to sign them up. And, you know, I have no control over the subscribers. I cannot sign anybody up. I can't even see all the subscribers. So if you want to sign up, you got to click on the Start Free Trial button. I have no control over that. Now, YouTube is in the process of committing suicide. YouTube has notified me that on 1st of December, my fee-based subscription channel, this one, will be terminated because they don't want any competition for their YouTube Red or YouTube TV. All the videos will basically go to a private mode where nobody will have access to them. But all of the exclusive content will still be available on my vid.me channel, and the link to the vid.me channel is below, is at vid.me/Sovereignty International. So you'll have to subscribe there too. So obviously you won't have to pay the subscription here if YouTube continues on this. I'm building a case against them, and so but if they go ahead with this, then that's what'll happen. And I'm seriously thinking about suing them because they're messing with my monetization and making it so that they're costing me a lot of money, quite frankly. Or you know, I mean, depends on what you say a lot is. But I've been out of work for 5 years, so to me, even a couple $100 is a lot of money. Anyways, this is all about slavery. He, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights, except those which the law and its humanity affords him. He is, for the time being, a slave of the state. And they should be put to death for doing this. If a man be found stealing any of his brethren of the children of Israel, and make merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. And that's why they have to get rid of that nasty little problem called common law. This is the 13th Amendment, which basically legalized slavery in America. Section 1, neither slavery nor involuntary servitude, except as a punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2, well, whatever. The point is that this legalized slavery in America. All they got to do is make something up. It doesn't matter. The courts have no interest in what the truth is or anything else. They just trump up a fictitious charge, and the Congress goes and helps them out by making all these charges. And then they go and Congress and the state legislatures say as long as they're doing it in good faith, then they get to get away with their assault, kidnapping, false imprisonment, thefts, and murders. And so they want them to do this stuff, and so it's about time we the people started taking back control. Anyway, so that's the 13th Amendment. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo. My YouTube profiles, I have two of them right now, Sovereign Living and Sovereignty International, although I expect that Sovereignty International won't exist after the 1st of December. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group on Facebook called Sovereignty International is being deleted. It takes time to ban 17,000 people off your group. My Yahoo private group, Administering Your Public Servants, and I have a Google private group called Administering Your Public Servants. Those ones are alive and well. Follow me on Twitter at EngineerWin. Follow me on vid.me. Follow me on Steemit at Sovereignty International. Anyways, there's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. That means it's always a statute. Think about it. Clerks, it's always clerks masquerading as judges, okay? It's all commerce. Matter of fact, I'm doing a video right now that there's no criminal jurisdiction. It's all civil. Everything is civil. It's all about business. Under Texas law, no act or omission is a crime unless made so by statute. Legislature may create an offense and in the same enactment provide exceptions to its application. Means it's statutes only. Clerks masquerading as judges only. That's all there ever is. Everything is an admiralty. A root of error doth not lie upon a sentence in admiralty, but an appeal. And that's Tomlin's Law Dictionary, 1835 edition, under the definition of admiralty. But they're citing Book 4 on Coke's Institutes and the Laws of England. And so its appeals are all in admiralty. That's why it's called a court of appeals. It's the same thing that precipitated the War of Independence, and I cover that in other videos. Check out my other videos: Bankster Thieves Playlist, Roman Cult Playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through 3, Do-It-Yourself, How Not to Volunteer for the Selective Service in the Draft, Martial Laws Here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail, Do-It-Yourself Kangaroo Courts, Canada Border Pigs Playlist, the Bar Members and their Satanic Connections Playlist. This is all coming from the Roman cult. The Roman cult is responsible for all slavery. See the International Law video. All bar members, judges, and lawyers are agents of the Roman cult. See Bar Members 1 through 3 videos. See the Judicial Horrors video. See the Void Judgments video. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private, corporate, commercial paper, Federal Reserve notes, and securities, which checks, is concerned. For purposes of suits, such corporations and individuals are regarded as entities entirely separate from government, and that's why you cannot pay their extortion, okay? And again, that's why they're when it's a statute, they're bought and paid for clerks, okay? So it's just a commercial transaction is all it is. It's all about business. That's why there's no criminal. It's all civil. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. Now, that's the Supreme Court in the case Downs versus Bidwell in 1901. So, the question you have to ask yourself is, which national government are you dealing with? Well, it's the unconstitutional one that's making all these statutes, and it's the unconstitutional one that's that if they're attacking you, that's the one you're dealing with, okay? So you have to understand that it's unconstitutional, and I don't care what it is. I don't care what statute it is. It's all unconstitutional. The at common law, that's the reason they have to pass these statutes for murder and assault and things, because under that unconstitutional corporation, anything's justified. And so it's all unconstitutional. A state, and this is a case, Chisholm versus Georgia, 1794, and this says a lot. A state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. A state is altogether exempt from jurisdiction of the courts of the United States and from any other exterior authority unless in special instances where the general government has power derived from the Constitution itself. The question to be determined is whether this state, so respectable and whose claim soars so high, is amenable to the jurisdiction of the Supreme Court of the United States. This question, important in itself, will depend on others, more important still, and may perhaps be ultimately resolved into one no less radical than this. Do the people of the United States form a nation? And then it goes on, by that law, the several states and governments spread over our globe are considered as forming a society, not a nation. And this, the caps, was in the original. And so the point being is that in 1794, there was no nations on this planet. And only one was the United States of America, actually. And so then, if there's two national governments, well, they've set up that society here. That's called the D.C. Corporation. And so the question is which one is the one that has jurisdiction over you? Okay, and so you have to decide. Do you know who you are? And so which one are you under? Everything they do is a fraud. A U.S. citizen is a fraud. Commercial paper, Federal Reserve notes are a fraud. All mortgages are a fraud. They get you to participate in their fraud, then they assault you with one of their so-called contracts, and they sell you into slavery. Everybody in prison was sold into slavery. So the bottom line is that the reason we're talking about this, give them the liability, is if you go in there and the judge says the Constitution, see what should happen? What should happen if he was the lawful judge that was honoring his oath? You should go in there and then he should basically interrupt, and you shouldn't have to say anything. Okay, he should take over. He should talk to the prosecutor, and the case should go away. That's what should happen. Okay, but if they're making you plead and they're making you do all this crap, then it's not a lawful court. Okay, so it doesn't matter whether he says the Constitution or common law doesn't apply in here, and I don't want to hear another word about it. I mean, really, is this over a statute? Okay, that's really what the crux of the matter is. Is this a statute involved here? And so then where's the contract? And so he's essentially saying if whether he comes out and says it or not, he says you're not in a court. If they're dealing with you, you're not in a court. He is not in his official capacity, and your response should be, this is not a court. You are not a judge. You are operating in your private capacity. You're not authorized to do anything on behalf of me, and if you do anything on my behalf, you're accepting full liability for the consequences. That's essentially what my notice and demand that when I send out, the first paragraph says, I accept your oath of office. The second paragraph says, if you think you're representing me, you're fired. And the third paragraph says that you're not competent in my affairs. And the fourth paragraph says I'm competent in all of my affairs. So the point being is that that's why they put you on the round robin, because you fired them. They don't have authority to do anything for you. And so that's, at the end of the day, that's what you're going to have to do, is tell them you're not authorized to do anything on my behalf, and if you do anything on my behalf, you're accepting full liability for the consequences. Now, the reason I'm bringing this up and the reason I'm doing this video is because there's people on my group that have talked about doing this, and the judge would immediately recuse himself, and the case would disappear. Okay, and so again, do you know who you are? Now, there's a lot of people that are extremely intimidated by all of this, and it is designed to be intimidating. There's no doubt about it. And so it's designed to be threatening. It's actually a felony. Okay. Anyways, so if you're afraid of actually coming out and saying that stuff, then turn it into questions, okay? You say stuff like, are you telling me that this is not a court? Are you telling me that you're not operating in your official capacity? Are you telling me that you intend to be personally liable in this matter? Where's the contract? And so they'll either throw you out or the judge will recuse himself and the thing will disappear, okay? If you stay there, they will sell you into slavery. Matter of fact, you're already their slave by just going in there, quite frankly. That's why I don't even go in there, okay? They're nothing but a bunch of thieves and pirates, and they deserve to be put to death, and I'm looking forward to that day. I pray for that day every day, and I think that we're going to see the day when we're seeing judges and lawyers hanging from light poles and things like that. But so I guess we'll see. My attitude is what's Christ say? Be wise as a serpent, but harmless as a dove. And so I just get up in their face, and it's amazing how they run and hide. Because that lawful government is still there. You just have to access it. And so, do you know who you are? Anyways, that's what I'm saying, is give them the liability and basically tell them you don't have authority to do anything for me, and if you think you're going to do something for me, then you're accepting full liability for the consequences. And that puts them in a very difficult position. I would definitely be telling them that. Anyways, appreciate you taking the time to watch the video. This is a short one today. Thanks for watching. Have a great day.